The Federal High Court sitting in Abuja has refused the bail application of the Defense Counsel to the 5 suspects allegedly involved in the 2022 attack on St. Francis Catholic Church, Ondo State, southwest Nigeria. Chukwunonso Nwabueze reports that the 5 suspects are facing a 9-count charge bordering on terrorism preferred against them by the federal government.
The trial judge, Justice Emeka Nwite, while delivering the ruling, stated that after due consideration of the 2 sets of affidavits for and against the bail application by defense and prosecution counsel, held that the character of evidence against the applicants are very strong. That considering the serious nature of the offense, the defendant applicants are charged with the nature and character of evidence against them. The respondent, which is the prosecution, has made a strong case of a likelihood of the applicants running away from justice and with no possibility of them being reapprehended, considering their connection to foreign fighter linked to the Al-Shabaab terrorist group. Justice Nwite further held that there is a strong belief that the defendant applicants will interfere with prosecution witnesses and undermine the effective and successful prosecution of the case, and in the process undermining the criminal justice system. He emphasized that he was not unmindful of the provision of Section 36 sub 5 of the 1999 Constitution as amended, which provides that every person who is charged with criminal offense shall be presumed innocent until proven guilty. This, the apex court stated, does not necessarily prejudice the presumption of innocence of the appellant of the charge brought against him until contrary is proved, but at least it tries to ensure avoidable interruption of the trial. And having carefully considered the affidavit evidence and the proof of evidence available before him, at this point in time, the judge held that the prosecution respondent has succeeded in raising a reasonable presumption of criminal responsibility on the part of the defendant applicants, consequently refusing the application.
We are happy with the judge for agreeing with our position that terrorists or terror suspects should not be allowed to roam our society. And the reason is because we have witnesses that we need to protect, as well as the fact that they may abscond if they are allowed to go out on bail.
We always look at it from 2 faces. Whichever it comes, they know more than us. That's why we call them the wisdoms. But remember, the matter has not finished. We are just starting.
The matter has been adjourned to the 16th of October 2025 with every likelihood of an accelerated adjudication.